We begin from the nation's capital, where the Supreme Court says Nnamdi Kanu has a case to answer. The apex court said due process was not followed by the federal government as it violated Extradition Act, but that will not stop the trial from proceeding. TVC News Judiciary correspondent Celestine Area has more.
It was not a good day for Nnamdi Kanu's family and friends as they had hoped that the Supreme Court would align itself with the judgment of the Court of Appeal. The Supreme Court swayed in another direction to say, although due process of criminal law was not followed, the federal government was in violation of Kenya Extradition Act and Nigerian Extradition Act. It does not render the trial an illegality. Justice Emmanuel Augim, who read the lead judgment, held that the violation of Mr. Kanu's right ought to have been filed by way of civil procedure. The lower court remained in the realms of sentiments in the case. Justice Augim asks if law enforcement means to do anything to enforce the law. He answers in the negative, as it does not mean to commit a crime to enforce the law. He says the court cannot uphold the judgment of the Court of Appeal.
The Supreme Court is the Supreme Court. What the Supreme Court says represents the law. We respect it. We go by it. We had hoped that it would come our way, but it has gone the other way.
Came very heavy on the security agencies where they have in any way, impaired on the rights, the fundamental rights of the defendant. However, our laws have made very clear provision for remedy. Where there's such infraction on the right of the defendant, then you can such a defendant can go to the civil court.
Mr. Kanu has been in detention since June 2021 when he was rearrested in Kenya after the federal government was alleged to have forcefully extradited him to Nigeria. He was arraigned before the Federal High Court in Abuja on a 4-count charge of treasonable felony, conspiracy to commit treasonable felony, terrorism, illegal importation of radio equipment.
Extract from the ruling of the Supreme Court today, Kanu as the father of the nation, issue a broadcast and then issue knowledge, discontinue the trial and grant him unconditional bail and commence the process for political and political solutions to the matter.
Although the Supreme Court sympathized with Mr. Kanu on how he was extraordinarily renditioned to Nigeria, the court says the law must remain the law. With this judgment, Mr. Kanu will have to go back to the Federal High Court Abuja and appear before Justice Binta Nyangu to answer to the remaining 7-count charges against him. Celestina Area, TVC News, Abuja.
Member of the House of Representatives, Ikenga Gochinyere, joins me on the news to discuss the court proceeding today. Thank you for joining us on TVC News at 10. Well, the Supreme Court explained that the judgment of the Court of Appeal was in the realm of sentiment. How do you react to that as a lawyer?
I think that even though we accept the judgment of the apex court, but we still disagree with some of the conclusions that led to the decision today. And those disagreements arises from the fact that there is no sentiment here, there's no emotion here. These issues were very clear. In their decision today, they affirmed that the invasion of his house in Omaha was constitutional. It was illegal. And then they also agreed that the extraordinary rendition from Kenya was also in violation of the law. Having made these critical findings, they would have expected the Supreme Court to do was to quash the trial because the basis upon which these new charges was filed, the condition precedent was not met. Maybe the Supreme Court did not take cognizance of the fact that there is an extradition treaty that has been signed in the law under Malami that said that for you to move somebody from another location to the country where you are alleged that he has committed the offense, there is criteria that is supposed to be followed. So when they say that some of these laws have not been nationalized, no. You know that once a treaty is signed and the country that is also involved adopts it and is ratified by the parliament, it becomes part of our jurisprudence. So there's no sentiment. What happened is that I felt we lost an opportunity today to show our seriousness and commitment towards resolving these key issues that have devastated a section of the country greatly. Lives have been lost, houses have been burnt, business have been crippled and crumbled. If the basic
After the court
of
sitting today, if you can hear me, after the court sitting today, counsel to Mr. Kanu, actually, Kanu Agabi, actually mentioned that, it didn't go in their favor, but they accept the decision of the court. And then in that report by our correspondent, you made a call for political solution. Can you differentiate this sentiment now, being attributed by the apex court?
Well, like I said before, I said what has happened in the Supreme Court, we have accepted it. Everybody have accepted. We have moved past beyond that. Now everybody's going to the appeal court. But I'm saying that even before they get to the appeal, to the court of Federal High Court, that the president, going by the urgency and the need to restore security of lives and property in the Southeast, and knowing that under Section 14 or thereabout, that the primary responsibility of government is protection of lives and property, that the president should invoke his constitutional power as enshrined in Section 1741C of the Constitution, that the Attorney General can discontinue any criminal trial at any stage before judgment. And why do we keep saying, let's stop, let's grant him bail, let's go back to the table?
But don't you think, Mr. Ogochinyere, don't you think that should then come from the defendant?
Well, the point here, if all of us are committed towards finding peace, whether the person who is prosecuting, whether the person who is defending, the most important thing was that we must agree as a matter of national urgent importance that we need to restore security in the Southeast. Apart from the military and the police offensive, there is need to take other options. And that is why I'm saying, let's explore this option. Let's go back to the table. And in going back to the table, you grant him bail. In going back to the table, you can discontinue the trial, even conditionally. And then we go back to the table, call all the stakeholders. Let me tell you why it's paining me so much, that when we had challenges that were different, like Niger Delta militant and so on and so forth, there was a conversation and discussions around the amnesty and so on and so forth. When we had things that were so bad, like the Boko Haram, there was conversation around amnesty and so on and so forth. When we had the challenges of the North Central, headers and farmers, there was a conversation, there was issue of Ruga and so on and so forth. Since we had this issue of challenges in the Southeast, there has not been any national conversation to sit on the table to say, okay, what is the problem? How do we resolve it? Is it that the lives that are being lost in the Southeast does not matter? Is it that the economic activities that is being destroyed does not matter? So I'm just saying, and I'm begging the president, as the commander-in-chief, he's somebody that have advocated for human rights as a leader in Nedeko, that what he needs to do is to call everybody together to the table and find a political solution. We will not achieve peace through this legal process. We will not achieve peace when we start going on who is wrong or right.
We'll have to leave the conversation there. You have made your point, Honorable. Thank you very much for talking to us. Ikenga Ogochinyere is a member of the House of Representatives. Thank you for your time on the news at 10.